if a vessel is hovering or it's on the water and it's not displaying lights legally required. Oscar had mentioned Rudolph's nose. But the failure to display your lights legally required is prima facie evidence that the vessel is engaged in smuggling or defrauding the revenue. So one can understand why it's quite important to have Rudolph so that Santa at least avoids the prima facie case that his sleigh is involved in smuggling when he lands on a rooftop.
Before we get started with the show, here's a quick word from our sponsor, Global Training Center. As trade compliance professionals, you want to make sure that your procedures and documentation are completed as correctly as possible to avoid any delays and possible fines. We provide a range of trade compliance courses that will fit your needs. From in-person or web training to recorded on-demand courses, we can train one or even thousands on your team through your learning platform or on our portal. We can even customize a private session for your team. Go to globaltrainingcenter.com to find out more.
Folks, we're here for a great show on SimplyTrade podcast, and we've got a good one today, and this is going to be a lot of fun. It's, we talk about so many serious things. Well, we've got some serious things to talk about in today's world here, and especially the holiday season. So this is going to be a great show. Something that I think will put a smile on your face, but it'll be something to make you think. I think that's obviously redundant, but it'll be something to stimulate your brain cells there. Let's put it that way, depending on how much you're consuming and what you're consuming. Lalo, I'm excited for this show. This is going to be a good one. We did a nice little take with Oscar last year, and so this is going to be a good follow-up to that. So I want you to talk a little bit about what we've got going.
It is, and I'm happy that we are able to keep this series, let's call it, even though it's an annual series, on the mystery of Santa Claus being a smuggler or not, or just all the fun stuff revolving around Christmas. And so we're picking up where Oscar left off, and we're trying to see just put together some more arguments for or against either way, or it doesn't matter. I mean, it's all in fun anyway, but I'm sure somebody will pick up some good trade advice anyway, or not advice, but information, so that's the end game anyway. And, but you suggested a buddy of yours, and I just met him, and although I know I've seen you a million times at trade shows, but I just never, I guess, met you in person. I mean, but I'm sure I've seen you at trade shows. But anyway, so our guest, Andy, do you want to go ahead and introduce him and where he's from and all that? Mm-hmm.
Yeah, Erik Smithweiss is very he's a very well respected attorney. He is somebody that people just love being around. He is a pleasure just to entertain as far as talking with him, being around him, and whatnot. But what's great is Erik not only is fun to be around, but he knows his stuff. So, Erik, I'll let you talk about your firm and what you're doing. You have been on a whirlwind tour, it seems like, with all of that. But you work with obviously several very well respected colleagues. Another one that's a good friend is Heather Lippman, and I love her to death. But welcome to the show, and why don't you talk about your firm and where you're at here.
Hey, well, thank you, Andy. I will say, Andy, I've known you for, back in the days where you were at FedEx and you'd show up for could be WestCon, it could be the ICPA. Didn't matter what the venue was. All I know is there was somebody from Customs and FDA up on the podium, and there was Andy Schiles in the back standing 6'5" with a 10-gallon hat and his boots on, letting them have it. Just calling a spade, as we like to say. So from that moment on, I knew I couldn't stray too far from Andy Schiles. That would be first comfort right there. So,
I'm not sure the customs and FDA officials will appreciate that, but it's like, yeah, we would always, never made it personal, but boy, I would jump on an issue with them, wouldn't I?
You jumping on it is a good characterization. It's probably the best we can say. In any event, it was good times. So, our firm, gathering it, a lot of the folks listening in on this are familiar with the Grunfeld, Desiderio, Lebowitz, Silverman, and Klestadt firm. I have the pleasure and privilege of having been at this firm now for so many years that I don't want to say it on air to age myself.
Yo,
right,
coot you.
right out of law school, as they say. I mean, maybe they'll make a movie one day and it'll be called Right Out of Law School. Who knows? But it's a lot of fun. It's a good group of folks. We do just customs and trade law. We don't do anything else. I don't know how many lawyers we have now, Andy. I won't say it's a revolving door. We're actually been pretty good. Like, folks have been sticking around, and we've got really great talent here right now. So I think we're hovering around 40, 45. We do just, the big ADCVD and trade cases. And then we got most of our lawyers doing what we'd all probably just call sort of garden variety custom stuff, although very little of our stuff is garden variety. Usually mine, got people slinking down the hall. They've got, dynamite, attached to their ankles. Somebody's about to light the fuse. And there aren't too many matters that show up on my desk that don't have some level of catastrophe lurking around the corner. So it's been a lot of fun, a lot of exposure to all areas of customs and trade. I've been teaching a class to prepare for the broker's licensing exam now for 20 plus years. So it's a real value doing that to keep me sort of fresh on what's going on and understanding stuff that maybe the average lawyer doesn't really. You ask the average lawyer how ACE works and what an entry is, they'll start scratching their head. But so with that in mind, let me know if you're ready to kick this thing off.
Well, just real quick, have you ever had I guess we should ask, have you ever had that certain character dressed in a red suit show up to your offices for help?
Well, I will say that having listened to Oscar's rundown of the potential charges, I would say that Santa's he's in a lot of trouble. But that's Oscar's problem. I'm not here to save Santa. I think Santa can probably, twinkle in his eye, wiggle his ear, and then I've seen it in the movies. It works like magic.
Well, I will say to our listeners, we've obviously made reference to a past show. It's last year's show. You need to go back and look at it. It was under the umbrella that Santa Claus is a smuggler and whatnot. So with that, some of the things that we come across here is that we've asked Erik to take a look at that and see what he thinks about some of the things. Obviously, there was one of the things that hit me from Oscar's deal was the implied contract with the kids, where the payment was through cookies and milk that was left in lieu for the presents that were coming in. So I'm like, okay, that's an interesting way to do that. But with that, I guess the other scenario here is with all the presents and whatnot. Would there be any, obligation, liability, or whatever else you would say towards the parents or the kids, or anything in the way Santa's handling things during the holidays here?
Yeah, well, Andy, parents don't get to skate free so easily. So we'll explore all of these nuances that stem from the prior presentation. One of the things I thought was really very interesting was the reference to a particular statute that's in the smuggling section that would allow a vehicle or the sorts that has been outfitted for purposes of smuggling to be subject to seizure. And there's one of the very interesting things is there's a part of that statute says if a vessel is hovering or it's on the water and it's not displaying lights legally required. Oscar had mentioned Rudolph.
Yes.
But the failure to display your lights legally required is prima facie evidence that the vessel is engaged in smuggling or defrauding the revenue. So one can understand why it's quite important to have Rudolph so that Santa at least avoids the prima facie case that his sleigh is involved in smuggling when he lands on a rooftop. All right. So with that in mind, I was quite taken by this presentation, and I thought let's think about whether we really have the greatest customs fraud of all time that is going on. And if so, is there anyone else that could be potentially held responsible for Santa's sandbagging of customs authorities, not only in the United States, but around the globe? So we're really looking at the failure to pay duties, and, well, quite frankly, in the billions of dollars, from what I can gather, on gifts that are being distributed to children. So I think, as we had pointed out, there is this general obligation to make entry of merchandise when it comes within the customs territory of the United States. And so one of the first things I wanted to evaluate is, does Santa just have a blanket exemption from entry under the provision that concerns articles returned from space? Now, I don't know how high the sleigh has to go to be considered to be in space. Or does it actually have to do a full orbit? Because it's quite possible that the sleigh is making it into space. I mean, it gets tracked on NORAD, it's going around the globe. Something to keep in mind. You might need to retrofit the sleigh with residual oxygen for the reindeer. Of course, these are fantastical reindeer. They may not need oxygen. Who knows? In any event, one of the things to be concerned with is, of course, articles that are returned from space, no entry is required. But there are lots of conditions, and it would have to have been gone up into space on a spaceship owned or operated by the United States, which brings in a whole host of issues about government contracting that we don't need to get into. Different issue. Okay, so assuming that it's not an article returned from space, I know Oscar touched a little bit about Section 321. And as we know, that would be our de minimis exemption. Now, to take advantage of the de minimis exemption, it is true that a formal entry is not required. And we'll get to this thing called the Type 86, which is a great mystery to many people in a moment. But when you do bring goods in, there is some level of declaration that is required. To bring goods in under Section 321, we know that we have to have a value limit of $800 per day destined to one person or to be imported by, and we'll get to the gift exemption. But what's very important is that $800 limit is based upon one person per day. Okay. Now, that would mean that many of these toys that Santa is distributing, let's just say the majority of toys. Now, granted, having raised 4 children, there are occasions when the $800 limit is exceeded. But that's usually when they get a little bit older and can be held better accountable. In fact, it won't even be in juvenile court potentially. So we have an $800 limit, and it has to be on a bill of lading or on a manifest. So keep in mind that when Jane and Jimmy and Ralph and Mary are getting their gift, okay, each one of those gifts must be itemized to that particular person, and it has to be on a manifest, which brings to bear the question of Santa's lists, right? Because we've been told that Santa is keeping a list, and he's checking it twice. And he needs to know who's been naughty and who's been nice. So let's start with the fact that you need to be on Santa's list. Now, hopefully you're on the nice list. If you're on the naughty list, then we got to start talking about prohibited merchandise and restricted merchandise. That'll
Yeah, assumedly, if you're on the naughty list, you're not going to get the good stuff. You're going to get the nefarious type stuff and whatever, right?
It could be. And then there could be federal agents parked in a car outside your door waiting, for you to exit. But you need to be on a list. So the Santa's list, let's hope that Santa's list can suffice as the required manifest for Section 321, and that each gift is thereby itemized. We need to be making sure that we have a fair retail value in the country of shipment that is not exceeding $800. Right? That's the limit. If you're below that, then you as the recipient aren't obligated to have an entry filed with you as an importer of a record. But that brings into question, what is the fair retail value in the country of shipment when you're shipping from the North Pole? Because there may not even be any retail trade in the North Pole. How do you have a retail value in the North Pole? That brings in the opportunity for all sorts of manipulation of values that are on Santa's list that Santa could potentially justify on the premise that in the North Pole, these items are valueless until they arrive at the intended location as identified on the list with the consignee's address listed. So I think under Section 321, there is the possibility that many of these gifts are going to sail right through. Okay? And I don't think we have to worry about it. Now, we do have concerns. These are maybe perhaps the more expensive gifts. You cannot have alcoholic beverages or perfumes containing alcohol unless the fair retail value, provided the fair retail value does not exceed $5. So I would suggest that if you are receiving alcoholic beverages as a gift and the fair retail value does not exceed $5, you might want to return it. Or perhaps bring it to the kitchen and use it for cooking. But these are the issues that come up under Section 321. Another problem with Section 321 is that you cannot have merchandise that is subject to absolute or tariff rate quotas. If something is subject to a tariff rate quota, you must pay the over quota rate. You cannot clear it de minimis without duty payment. That's in the law. Think of this. Let's suppose that the gift is cookies or other food that one would be typically receiving, perhaps in a box, around Christmas time. Most of these Christmassy type foods are going to have what is subject to tariff rate quotas? Well, peanuts are, but we don't need to go down the peanut road. Sugar. And what do little children like? They like sugar. Once you get sugar over 10%, and certainly over 65%, those tariff rate quotas are going to kick in like mad. Therefore, you're basically, to the extent that Santa has on his sleigh food products containing over 10% sugar, in all likelihood, we are seeing constant violations of Section 321. I think Oscar was right. Santa is a smuggler, not just of animals, but also of sugar-containing products. Another issue that we may have is we could potentially go with bona fide gifts. Right? There's a separate exemption for bona fide gifts. Now, the dollar threshold is a lot lower. It's only down at $100 to have a import by a bona fide gift. The interesting thing about a bona fide gift is that it simply has to be received by the person here. It's not something they would necessarily order. But to be a bona fide gift, it has to be provided by the donee, by Santa, without compensation or promise of compensation. Now, as I have heard, there is a problem here, because there seems to be implied compensation to Santa upon arrival, coming down the chimney, hopefully with the fire not raging, where Santa will be compensated through cookies and milk. Well, if the gift is being given in exchange for cookies and milk, it no longer qualifies as a bona fide gift. So Santa's back on the hot seat, if you will, for non-compliance with entry requirements under 19 U.S.C. 1484, Section 321, and corresponding regulations. Well,
I'll tell you, Santa is up a proverbial creek.
I mean, there are declaration requirements. I mean, you've got to be able to identify not only the value, but you've got to be able to provide information on the country of origin of the product. Country of origin, well, let's just say that Santa's workshop maybe isn't substantially transforming everything. So we're going to have a potential issue on country of origin. And of course, you're going to need your ultimate consignee name and address, which is going to bring me now to the questions about the ultimate consignees and whether or not the ultimate consignees can actually put on their blinders, throw up their hands and say, I'm not the importer. Santa's the one that smuggled it into the United States on a sleigh, no less, and might not have had the legally required lights in effect at the time of arrival. So, with that in mind, do our children have to be concerned about any potential liability for duties that have been evaded by virtue of the greatest smuggling operation of all time? And what about the parents of said children? I do have concerns here. I think that there is a misperception among many folks in the trade that only the importer of record can be held legally responsible for duties and penalties in the event of a non-compliance. And that is not the case. So let us run down liability lane. Little different than candy lane, but
well, in this case, before you go any further, I mean, as you were going through, you were looking at it as the term ultimate consignee, which from what it appears is that in the de minimis transactions, customs has looked at it in general, that the ultimate consignee would be considered the importer, not necessarily the importer of record, but the importer, because they're the ones that is causing that item to come into the country and they take possession of it.
Well, Andy, those are the gray areas that us lawyers, we just love that area. I mean, you just put me on an island and say it's gray, I could stay there all day long. Okay. So you are right. There is no importer of record on a Section 321 shipment. By the way, same for a Type 86. They put in an importer number to facilitate Type 86, but there technically is no importer of record on a de minimis shipment or a Section 321. And obviously no importer of record with this massive smuggling operation anyhow, because no one has filed a declaration. But yes, the ultimate consignee has to be viewed as the importer, and it has to be imported by that person in order for the 321 to kick in. It does raise questions about whether customs could reach this ultimate consignee for an assessment of duties and potential penalties, and the answer is possibly yes. So 592 is the principal penalty statute, which allows customs to do two things. One, to impose a penalty on any person that enters or introduces merchandise by means of a material false statement. Example, a manifest that misstates the fair retail value in the country of North Pole, or that has a material omission, which would be simply bringing goods in and not stating accurate information about the goods. So you could have a violation under 592. So it allows for a penalty against any person involved in that activity, and it allows the recovery of the duties that have been avoided by virtue of these violations. The statute also provides for penalties against any person that aids or abets such a violation. This is where I have my concerns, because if the children have knowledge that Santa will bring gifts through the avoidance of duty payments, they accept said gifts and, in addition, provide a form of compensation for the gifts in terms of cookies and milk, I believe that could bring sufficient knowledge upon the children that they may be said to either have been participating in the introduction of the merchandise or potentially aiding and abetting what would be a intentional violation by Santa. And to be very clear, the aiding and abetting liability requires intentional violations. Mere negligence by Santa would not result in an aiding and abetting charge. However, clearly Santa is not negligent. Santa's been doing this, since forever. So you would think after a few times, he's kind of got the idea down. Okay. We do also have some other potential liability as well. So there's another penalty statute that is primarily used for the introduction of merchandise contrary to law. Okay? It's 19 U.S.C. 1595A. That's a little a. And subsection A is for the seizure of goods that are for vessels being used to import contrary to law, hence the sleigh and reindeer. And subsection B allows for the assessment of a penalty up to the value of the merchandise that was been introduced contrary to law. And we know that assuming that Santa is not going to meet the de minimis requirements, that we have an introduction contrary to law. And that penalty can be imposed on every person who directs, assists financially or otherwise, or is in any way concerned in the introduction of merchandise contrary to law can be assessed a penalty. It is not limited to the man with the reins behind the reindeer on the sled. This would be anyone, any way concerned. And this is where CBP could seek to impose penalties on complicit children and potentially their parents. Let's talk about the parents for the moment. Let's suppose that the provision of cookies and milk to Santa makes one either an aider or abettor or adequately involved to facilitating this unlawful importation. Where do the children get the cookies from?
It's like this is reaching out like tentacles here.
Parents are going out and either purchasing the cookies for purposes of inducing Santa to smuggle gifts into their home. Or maybe if you've got a really motivated child who has a potential future in baking, maybe they bake their own cookies, but the parents are acquiring the ingredients with knowledge that the cookies will be baked and used to facilitate and participate in the introduction contrary to law. So it is important for folks in the trade community to understand that there are statutes which would allow the government to reach beyond the actual party importing and impose penalties and potentially recoup duties as well for folks that are what we call the downstream purchasers or consignees. And in fact, it should not come as a surprise to folks that this happens. Let's bring into play another statute which has really made a bit of headway in the last number of years. And I think folks have probably seen a lot of press releases. Our law firm has been involved in many of these cases, some of which have resulted in press releases that concern our clients. And this is something called the False Claims Act. And I know folks generally are becoming more familiar with this. So this is a statute which says if you make a false claim to the government to obtain money, you commit a violation, and a whistleblower or the government itself could bring a civil lawsuit to recover triple the amount that the government has been defrauded. It also has this thing called the reverse false claims, where if you file a false declaration with customs to avoid payment of duties, you would be liable. And the statute would impose liability on any person who knowingly makes or uses a false statement to avoid or decrease an obligation to pay, as well as anyone that knowingly causes that false statement to be made. And knowingly is defined to include reckless disregard for the truth or falsity. So if we bring this into the context of the Christmas season and Santa's Christmas Eve journey, I don't think it's a big stretch for the Department of Justice lawyers to say that the children and potentially the parents are knowingly causing the avoidance of duty by virtue of their participation annually in the great Santa scheme of duty evasion by the provision of cookies and milk as an inducement. Let's just say that I've seen the government try to make cases against potential defendants on much thinner evidence than cookies and milk.
Well, I will say, as you're going down this road, I can see the liability and participation, if you will, of the parents in increasing that liability. With, the children may be innocent victims out of this, but they're still caught in the quagmire. But as parents take their children to see Santa and have photographs of Santa who is obviously not the real Santa, but an agent working on his behalf, promoting the whole concept of this whole scenario, and especially with the cookies and milk, leaving that for them and whatnot. I can see where the risk to the parents, based on what you're just saying, could be astronomical.
Oh, for sure. I mean, it makes refuting, knowledge and awareness almost impossible. I mean, you went and you had photographic evidence of participating in the effort to induce Santa to smuggle gifts into the home. Johnny sits on the lap. Santa says, "What do you want for Christmas?" Boom, right there. I mean, imagine if it were recorded. And you know what? You shouldn't assume that it's not being recorded. There are eavesdropping. This brings me back to a forfeiture case. So, Andy, I had a forfeiture case a number of years ago, which, by the way, not only did we win, but the government had to pay our legal fees on behalf of our client. But in the course of discovery, that's where you get documents from the government, I saw a transcript. It was typed out, and it was a conversation between my client and the target of a federal criminal investigation that was tangentially related to my seizure case. And in that conversation that they appeared to be on this transcript was my client relaying legal advice I had given to him and that he was relaying to the target of the investigation. Needless to say, I was concerned about seeing that in writing in a transcript turned over by the government. So I promptly called the assistant U.S. attorney and asked if he had obtained a search warrant to obtain and intercept that phone call, to which he relied, I cannot comment on that. That was his reply. So everyone should also be aware that law enforcement authorities routinely intercept cellular communications without a warrant. They do it all the time. They can't intercept landline conversations because they have to physically tap into the line, and they can't do that bypassing the phone companies. But cellular communications, they just flip up an antenna and they can intercept stuff all the time. Now, whether they can use it in evidence is a different issue. But once they read it and they absorb it, then they know who's guilty and who's not guilty. So keep that in mind. Having a burner phone can be helpful, but it doesn't necessarily get you out of the woods.
Yeah.
That'll be for an episode of Better Call Saul. This brings me now to my concern about potential criminal liability. I mean, it's one thing for CBP to send out a penalty notice and say, you owe the government a penalty equal to the value of the merchandise. Okay, so you got in $500 worth of gifts. The government wants their $500 penalty. You can go through the mitigation procedure, maybe have to pay some duties on it. That's okay. But when there's an assistant U.S. attorney that wants to indict said parent for its complicity in the smuggling operation, that changes everything altogether. So there is a statute, 18 U.S.C. 545, which, of course, makes it a prohibited act to knowingly and willfully, with intent to defraud the United States, introduce or attempt to introduce clandestinely merchandise into the United States, which is exactly what Santa's doing. And that brings some concerns with respect to the parents who are now knowledgeable, because in addition, it is also a felony to transport, sell, conceal merchandise after importation with knowledge that it was imported contrary to law. You see, this brings us into the area of what do you do in the forced labor environment where there is goods that came in which you determine after importation were made by an entity that's on the bad list under UFLPA, the Uyghur Forced Labor Prevention Act. Now you know the merchandise was imported contrary to law. Now, you might not have done the importing. You may have purchased that product. But if you have reason to know that the goods were smuggled into the country, your act of further transporting them or selling them is itself a felony. So, parents, beware, okay?
Even after you get the gift and open it up.
Your child got the gift that they didn't want. Be careful before you let them re-gift it, because that's been a transportation of merchandise with knowledge it's been imported contrary to law, and that's a felony.
Well, and there is a possible argument for the forced labor of elves in manufacturing these items in the North Pole on certain gifts. So there's another scenario there of being able to prove that it is not forced labor, that they are being paid and all of that as well, right?
Well, for sure. And, of course, as long as they're not traceable to Xinjiang, that should be fine. But imagine you have a camp up in Santa's workshop that has some temporary workers. Now, also, by the way, if those workers are from North Korea, also makes the merchandise prohibited. Something people tend to forget is that under the Countering Our Terrorist Enemies Act, whatever, I forget the name of it. Pardon me. Goods made with North Korean labor are presumptively made with forced labor and are prohibited, whether or not they're from North Korea, from China, from Germany, or the North Pole.
Well, there have been those that have said too, he's like, what is the actual origin, if you will, of the elves themselves? They could be elves from all over the world. So,
Well, it's certainly a valid point, and it's important when we think about social compliance for UFLIPA, as well as because we do have these listed entities and folks that are workers that are being compelled to participate in those programs. We've got North Korean workers, and those, of course, are big issues. Fortunately, the ethnicity or nationality of the laborer is not relevant to the country of origin determination. All that matters is that the elves are able to substantially transform the Chinese PCB boards into a new consumer electronic product at the workshop. And if they're not mounting the PCB with the discrete chips, then you're going to probably have a problem. It's probably still going to be a China country of origin. So, in any event, so we get to this point now where we have potential criminal charges. Now, we've heard that you've got this election interference case going on down in Georgia that has 24 defendants all at once. Well, let me tell you something. That's nothing. The Santa case is going to be the case of not just the century, it's going to be the millennia. I mean, think about how many potential defendants there's going to be in this case. All of these complicit parents. And then some of these kids, Andy, they're not so innocent. Okay? I mean, granted, we're probably going to have some of these cases now heard in juvenile court as well. It's going to be a total mess.
it's going to clog the system.
Right, which is probably why there will be prosecutorial discretion not to pursue charges. Because Christmas will be much more joyful if Santa does not, and the children and the parents are not incarcerated. So hope everyone on that note will be having a joyful Christmas and be wary of cookies that have evaded sugar quota.
The question is what to do. It's like take care of your own gifts. Make sure you know where they're from.
What I would suggest to all children is do not expect any gift that's over the $100 bona fide gift limit. That's where you should start. All right. If we can all just limit our gifts to under $100, I think that would solve most of the problems that we have right here. Sadly, I can't get my kids on board with that.
Yeah, no way.
From a standpoint of trying to avoid any of the scenarios that you just described, yeah, it's like, all right, kids, we're going to have a very low dollar Christmas this year. See how well that goes. Erik, I love it. This is fantastic. I tell you, this is an aspect of the 321s I had not thought about, and the implications thereof that keep reaching out.
And you probably hope never to think of it again.
Yeah, it's like oh my gosh, I was like, okay, this would be a horror story. On a different note, people that are, shall we say, ordering their goods online, e-commerce, from a serious perspective, and have it shipped directly to the giftee, the person receiving the gift. I wonder if there's any implications in everything that you just said, the way it comes in.
Well, probably. I mean, to be a little bit more serious about this, I would expect that it would be treated the same whether or not the person who actually physically places the order is the consignee versus somebody else. That would not make a difference. In fact, I've had some spirited conversations with our colleagues at CBP about 321 and whether or not the $800 provision, as opposed to the gift provision, really requires somebody to have ordered goods, or what if goods just show up and the consignee is not aware that they're coming, and does that have any relevance to application of the provision, which I would argue it does not. But I think folks will be fine. In fact, I would encourage your listeners to test it out. Send me as many gifts as you can. Remember, no alcoholic beverages under $5 with fair retail value. That would be discouraged. And I will represent you for free if you get into trouble.
There you go. Erik, as always, you have a great sense of humor. I love this. And this would be one of those where, some of the kids that are ready to, if they require your services, they may be hitting their piggy bank and coming out with some shiny pennies for you.
Pennies are still legal tender. So, yeah.
I love it. Thank you, Erik. I appreciate it. With this, folks, I will tell you, this is one that I hope you had some laughs, because I know Lalo and I both were sitting there cracking up on some of this. It's outstanding. With that, leave you with some deep thoughts on the whole Santa Claus enterprise. But seriously, folks, Merry Christmas to you. Merry Christmas and happy holidays to you, Erik, and your whole crew, and especially your colleagues out there. And I just you have a great group of people that I know you work with. So appreciate you.
Thank you very much, Andy. Merry Christmas to you and your family, and you too, Lalo.
Thank you so much. Have a good one. Thank you very much for joining us. SimplyTrade is brought to you by the generous contributions of Global Training Center. You can follow the show and GTC on LinkedIn or Twitter and other social networks. Make sure you check out the show notes in the description for a full rundown of today's show with all the important links. Also, make sure that you share this with a friend and subscribe on your favorite streaming platform. We really like hearing from you. If you enjoyed the show, make sure to rate and review wherever you listen to this podcast. If you or someone you know would like to be a guest in the show, or would like to sponsor SimplyTrade, or suggest any topic you would like for us to discuss, please contact us via email at simplytrade@globaltrainingcenter.com, or you can DM us on Twitter at SimplyTradePod. Thank you again for the privilege of your time. Happy trading. SimplyTrade is not a law firm or an advisor. The topics and discussions conducted by SimplyTrade hosts and guests should not be considered and is not intended to substitute legal advice. You should seek appropriate counsel for your own situations. These conversations and information are directed towards listeners in the United States for informational, educational, and entertainment purposes only, and should not be substituted for legal advice. No listener or viewer of this podcast should act or refrain from acting on the basis of information on this podcast without first seeking legal advice from counsel. Information on this podcast may not be up to date depending on the time of publishing and the time of viewership. The content of this posting is provided as is. No representations are made that the content is error-free. The views expressed in or through this podcast are those of the individual speakers, not those of their respective employers or Global Training Center as a whole. All liability with respect to actions taken or not taken based on the contents of this podcast are hereby expressly disclaimed.